So the next case is U.S. v. Virginia, and Justice Ginsburg writes for the court here. Um, Justice Ginsburg has not been in court for a particularly long time in 1996. She was nominated by President Clinton, and so there hasn't been a long amount of time that President Clinton has been the president. But the reason why Justice Ginsburg was nominated to the court was because of her trailblazing service um, as a women's rights attorney in the 1970s and 80s. There's really no question, and Bill Clinton was, you know, as forthcoming as you would expect a president to be when someone as notable as Justice Ginsburg is being nominated to the court. So this is really the first issue that comes before the court when Justice Ginsburg is on it that deals with a gender-based distinction. And it's kind of a doozy. So U.S. v. Virginia centers around a public university in the state of Virginia known as VMI, or the Virginia Military Institute. Um, its mission, as identified during this time period, was to produce citizen soldiers, whether their graduates either entered into military or civilian life. And so in that regard of that sort of mission, it's important to note that only 15% of graduates from VMI actually went on into military careers. So the United States sues the state of Virginia uh, for their male-only policy, charging that it is a violation of the Equal Protection Clause, so a violation of the 14th Amendment. The district court finds in favor of VMI. The Fourth Circuit reverses. During this time period, and the only reason why I explain that is that during this time period, the state of Virginia proposes a parallel program that would take place at the Virginia Women's Institute of Learning that would be located at a private school. It would have a system that looked very much, in fact, almost identical to the system of VMI, but was for women only. And so if this sounds of shades of the sort of separate but equal systems that were done for higher education in terms of law school, medical schools, etc., it should, because it's kind of that. But when the case makes its way all the way to the Supreme Court, um, the Supreme Court reverses both decisions that were made, because there was a decision first about whether this was a violation of the 14th Amendment without the separate Women's Institute. Then they create the separate Women's Institute, and both the district and the circuit are okay with it. And the Supreme Court just reverses both of those and say, no, there's no system under which a male-only institute of higher learning can be supported. Um, at one time in the state of Virginia, there were certain programs that could be found only at VMI, so that VMI offered something different and something unique. But in 1996, all of the programs at VMI could be taken at other state schools. So there was really nothing distinctive about the programs that were offered at VMI. And so specifically, the Supreme Court states that the mission of VMI was indeed special, had a special mission, and therefore, by excluding women, was constitutional, because women had no opportunity anywhere to gain the benefits of the system of education that was offered at VMI. Justice Ginsburg, in the majority, cites two cases in support of their decision. Frontiero and Craig v. Bourne. Shouldn't shock you in large part because she was one of the attorneys who argued those cases. She writes that the inherent differences between men and women we have come to appreciate remain cause for celebration and not for denigration of the members of either sex or for artificially constraining on an individual's opportunity. Sex classifications may not be used as they once were in Gossard to create or perpetuate the legal, social, and economic inferiority of women. Justice Ginsburg now gets to the discussion of scrutiny. She brings up the topic of intermediate scrutiny and states that regarding the state of, and argues that regarding the state of Virginia, quote, we conclude that Virginia has shown no exceedingly persuasive justification for excluding all women from the citizen soldier training at VMI. Remembering Craig v. Bourne, the justification was an important justification. Justice Rehnquist lowers that in Michael M. Here, Justice Ginsburg really just dials it up. Exceedingly persuasive justification is the standard here. So if we make the argument that Justice Rehnquist lowered the standard to be a lot more like rational basis, exceedingly persuasive justification sounds like Justice Ginsburg has raised the standard to be a lot more like strict scrutiny, which isn't so much a shock. But what this does go to show is that there really exists no agreement on the court about where intermediate scrutiny sits. It's not clear where intermediate scrutiny lies, and it really appears that it's dependent upon who's writing the opinion. The court goes on to say that even this parallel program was insufficient because it was based about the existence of VWIL was based on generalizations about the way women are, estimates of what is appropriate for most women, and those no longer justify denying opportunity to women whose talent and capacity place them well outside the average description. Because VWIL standards were different than VMI, that distinction wasn't good enough. And so Ginsburg, sort of concluding in this regard, states that the history of the court is the story of the extensions of constitutional rights and protections to people once ignored or excluded. VMI's story continues as our comprehensive understanding of we the people is expanded. So in Justice Ginsburg's first case on the court, first case dealing with gender-based issues on the court, she articulates exactly the sort of opinion you would expect from someone who had spent the better part of their adult life fighting for the tearing down of gender-based distinctions in the law. Now, there is a concurrence in this case. The concurrence in this case comes from Chief Justice Rehnquist, the same individual who had, in Michael M. and Rostaker, lowered the intermediate scrutiny standard, and who in Craig v. Bourne had said that there needs to be no intermediate scrutiny standard. What Chief Justice Rehnquist writes in his concurrence is that he agrees with almost everything that Justice Ginsburg says. His only distinction from her opinion to what he would want is that the exceedingly persuasive justification went beyond the traditional standard of important governmental interest in the intermediate scrutiny test. So the only thing in totality that he disagrees with in her VMI opinion, or at least disagrees with textually, is that she raised the standard of the intermediate scrutiny test. Seems kind of shocking from an individual himself who has lowered the standard of the test in their own opinions. But it also shows, at least to some extent, how much Justice Rehnquist has come around, in this case, Chief Justice Rehnquist. In 1976, literally 20 years before this case, he articulates a dissent in Craig v. Bourne that says that he disagrees with the notion of intermediate scrutiny and disagrees with using anything but rational basis standard for laws that discriminate on the basis of gender. And 20 years later, he's defending an opinion, a test that he disagreed with. that's a bit of evolution, and I want to put it in the confines of what's going on. So Chief Justice Rehnquist at this time has been Chief Justice for a number of years and has been serving on a court for a large portion of that time with at least one woman, Justice Sandra Day O'Connor. With the nomination of Justice Ginsburg, he is serving on a court with two women. In 1976, he was serving on a court with no women. What we know from extant political science research is that serving on a collegial court, that is a court that is comprised of other members, and those other members have to come together to make a decision, that when you serve on a collegial court, the decision-making of that court, even when controlling for ideology, is different when you include a woman on the panel of judges. And it gets to be even more different when you include two or three. The same finding holds true for when you take an entirely all-white panel and begin including people of color on the court. That the judge with, or the court with literally one person of color will decide cases differently than an all-white court. So one of these two things is going on, but it seems to at least be describing a situation in which Justice Rehnquist has in some ways evolved over time. There is indeed only one dissent in this case. It's a 7-1 case. I don't think Justice Thomas takes part. Justice Scalia does dissent. He doesn't like 3 different tests and 3 different distinctions: rational basis, intermediate scrutiny, strict scrutiny. He argues that when a practice is not expressly prohibited by the text of the Bill of Rights, and it also bears the endorsement of a long tradition of open and widespread unchallenged practice, that the court has no proper basis for striking down those distinctions. So in essence, what Scalia is arguing is that if something has not been specifically prohibited, the answer of "we've been doing it for so long" is enough of a justification to keep on doing it. The reason why I cover Scalia's dissent at all is to note that this is his dissent is in essence what Justice Rehnquist's dissent was 20 years prior. And Justice Rehnquist could have signed on to Scalia's dissent easily. It wouldn't have changed the outcome of the case at all. Virginia would still have lost. The United States would still have won. But he takes time to join the majority and concur, simply disagreeing with Justice Ginsburg's increasing of the intermediate scrutiny test. And I think the fact that he's in the majority, when there exists a dissent that very clearly is a position he previously has held, does speak to some extent of the evolution of Justice Rehnquist over time.